above policy limits, and that's the important thing. It
But
says it
Counsel,
doesn't.
isn't their obligation to pay above policy limits only triggered if there actually is a payment of interest? And how can we know? And it is your burden because you're arguing they have a greater obligation under the policy because there's provision, but it only comes into play if it was a payment of interest. Where is the proof in the record that at least some portion of this settlement amount that you entered into was for the portion of interest as opposed to for, the substantive liability under the verdict?
Well, at the time that the settlement was entered into, in February 21, there was about a $433,000 gap between the judgment and accrued interest and the settlement, okay? And so it's our position that that exposure existed, and the only way to have a real remedy, let's say it was an insured and there was no excess policy, because we're stepping in the shoes of the insured for equitable subrogation, so the rights are the same. We get all their rights once we paid. Once you have that, those rights attached, and it seems to me as a matter of public policy, and reading this in favor of the insured or its subrogee, us, Allied World.
Well, this is a fight between two insured, so this is.
No, but
Go ahead with your explanation, because I still haven't heard it.
Okay, but the thing of it is we're getting the insured's rights here. We have no direct contract with them.
Right, but, okay,
Okay.
let's assume you're getting the insured's rights. Where's the proof that some of the settlement payment was for interest?
Well, the thing of it is you do the math. We got a savings of X amount, of $433,000, and the difference had to be the interest. In other words, if we had gotten...
You're asking us to just assume that? I mean, how do we know?
I think
Plaintiff could very well say, I don't want to keep litigating this. I'm willing to take an amount under the jury verdict and forego my right to interest. How can we possibly know without rampant speculation what that settlement consisted of?
I think the burden of proof is on Greater New York, and this is why. Once the judgment is entered and interest is running, there are obligations attached. For them to now say, because there's a settlement, we're terminating that rights, it's not in their policy.
Counsel, the question isn't, to be honest, whether they're terminating the right. The question is whether any amount, assuming we don't buy their other argument about that it was an offer and that it really was, and we accept your argument,
Okay.
you still have to come forth with some proof that that provision came into play. And to come forth with that, you have to come forth with some proof that the settlement amount consisted somewhat of interest, because plaintiff had every right to forego any interest and just settle for an amount under the jury verdict. So what's the proof?
No, I think you can presume it.
Why? Because there's always interest?
Because they're giving you
that's basically
a
what you're
discount.
saying is that there's always interest, and so...
No, there's not always interest because most settlements are before judgment, before trial. But this is a unique circumstance once you have a judgment and
Not
interest
that
is
unique.
running.
It happens all the time that cases settle after
I understand,
judgment.
but
It
most of the
happens all
cases
time
settle
that
before.
plaintiffs
But see,
forego
the
interest.
It doesn't matter. It seems to me because there's a discount here, you can presume that interest had to be included. How could it not be? Okay?
I mean, there are reasons why, possibly was not, and you're saying that the burden is on them.
Right, because it was triggered already. That's the point I'm trying to make. Once they have an obligation, that judgment attached, they had an obligation to pay money. In addition to limits.
Is there
to say that stopped after the settlement, that's their burden.
Is there any piece of paper, any judgment that says interest where signed by a clerk?
Well, there's interest included in the judgment. Pre-judgment interest is definitely included in the judgment before the settlement. I mean, that was $41,000 or whatever. So some of this was included. Okay. Thank you, Your Honor.
Your Honors, 2 points I want to make. One, with regard to the offer. Our policy specifically says make an offer to pay. Our language used specifically said, we are paying you $1 million so that you can use it if you want to settle it. And again, I go back to the point at the end. They had that letter. February 12th, 2020, they had that letter. They don't respond.
But was it an unconditional letter? Didn't it say that you have to waive any claim for interest if you want to accept it? So why wasn't it a conditional letter, which under the law is not sufficient to relieve you of your obligations to pay?
So, Your Honor, 2 things on that, if you don't mind. The condition in the letter was already satisfied. There was no interest owed at that point of the letter. So it was satisfied. So while they phrase it as there was a
Weren't
condition.
you the one who put in the language that the offer was to be construed as an offer to settle and was contingent upon AWAC's written agreement that AWAC was not responsible for post-judgment interest? So you're the ones who put in the condition. You didn't need to put in that condition. You could have just said, here's our tender, here's the million, take it.
Correct, Your Honor. We
didn't
did
do
put that
that.
in. We did put that in the letter. But our policy specifically doesn't use the term unconditional. In the cases cited by our adversary and by the court below, those cases use the term offer to settle. That's a different term. So under our policy conditions, under that supplementary payment provision, it specifically uses the term offer to pay. The word unconditional is nowhere in there. And then if in fact it was ambiguous, given the provision Your Honor's referenced, it was incumbent on them to come back to us. In fact, that's what we cited in our third point, that Insurance Law 2601, the New York regulations for insurance companies, require them to respond within 15 days. It could have ended 15 days after, no response.
I think
Months.
that's only between an insured and then, it's not between insurance, anyway, it's not between insurance companies, that provision.
Well, the provision
You're
specifically,
two insurance companies, you're not an insured and an insured.
right, but it doesn't, the insurance law just says you need to respond to a settlement communication. It doesn't say between each other versus from your insured to an insured. It's designed for responses to be forthcoming for all parties involved to know. And candidly, as an insurance company who wrote the letter, to then be forced down the road to pay something because someone's saying the letter was either ambiguous or did not do what you conveyed it did, we could have ended it 15 days after had someone complied with the NYCRR or New York insurance law.
Thank you both.
Thank you, Your Honors.
Reyes versus Perez.
Good afternoon, Happy New Year, and may it please the court. Andrew Left of Nguyen Left for the plaintiff, appellant Samuel Reyes, the now permanently injured emergency medical technician involved in this accident. The accident involved the emergency medical response to a pediatric asthmatic patient, which is a potentially fatal emergency.
So why are there no issues of fact as to whether or not the ambulance did in fact have on lights and sirens? And you have a witness, an independent witness, who stated that the ambulance did not have lights and sirens on.
It's a good question. Even if, in the face of an authentic, contemporaneous, and purely objective video with audio, which clearly displays lights and sirens on the entire response until the impact, even if this questionable witness who first appears 4 years after the accident and didn't give his information to anyone at the scene, including EMS personnel and the police, even if that witness could raise a question of fact as to whether the siren was audible at the time, whether he could hear it, and whether that was enough to raise a question of fact, we don't have to reach that here because there's redundancy built into the system. So an ambulance has to have lights and sirens as it's traveling, and it is undisputed that the lights were flashing down Columbus Avenue, and there's still no
The affidavit said, the affidavit in issue, it said that there were no lights and that the sirens were not audible. Having looked at the video,
It said that the lights were dim. He thought the lights were dim.
You're right. You're right.
The lower court didn't find any question of fact about the lights whatsoever. The lower court,
or the sound.
the lower court found only that there was a question of fact as to whether the sound was audible at the time. And even so, the bus driver,
Was the video? I'm sorry. Was the video submitted to the motion court
yes,
for review?
yes.
Didn't the motion, I'm sorry. Didn't the court state that she viewed the video from the dash cam in the ambulance and it was unclear as to whether the lights and the sirens were on at the time of the collision?
She found that it was unclear, I think only as to the audible portion, and at the end of the decision, she clearly writes the question of fact that she found was whether the sirens were audible at the time.
I'm reading right off of her decision. The court also reviewed the video from the dash cam in the ambulance, which is unclear as to whether the lights and the sirens were on at the time of the collision. Page
Right?
2 of the decision.
But it's undisputed that they were on. I mean, the witness at best said that they appeared dim to him, but they
Well,
were
the
on.
question is whether or not they alerted, or they served the purpose of alerting that they were coming through the intersection.
Correct, and that's why the video is particularly enlightening as to that regard, because
But we have an independent witness who states that he didn't hear any lights and sirens. And I thought the crossing guard also, who was at that corner, also made a statement that.
that's a bus driver hearsay statement. We have no evidence from a crossing guard. The bus driver testified at his deposition that the crossing guard said, "I didn't hear anything, or I would have directed traffic."
Right.
Meanwhile, you can clearly hear it the entire time. And most enlightening of all is if you watch the video and you watch the ambulance approach the intersection where the accident took place, let alone all the other intersections that they passed through on the way. If you watch this specific intersection, if you don't mind my turning my back for a second, but as the ambulance is heading down, traffic is coming from the right to its left, and there are two cars. There's a car and a bus in two lanes. And the car, clearly we watch it come to a stop, having seen and heard ostensibly the ambulance approaching. And the school bus just ignored it and went right through. And so with the question left to us, the question becomes, why didn't the bus driver see what was there to be seen and hear what was there to be heard? And a witness saying, "I didn't hear anything," doesn't really explain why the bus driver didn't hear anything.
Thank you. Thank you very much.
Thank you, Your Honor.
Take care, Mr. Nguyen. Meyer versus Cabot Lodge.
May it please the court, my name is Brian Murray from Glancy Pronge Murray, representing the appellants. I believe you said you studied all Christmas, reading the papers, so I won't belabor the facts.
Especially this one,
Oh, Lord.
because this one was so interesting.
I'm sure it was.
So the question becomes now, when did the breach of contract claim accrue?
Precisely, Your Honor. That's
What's
exactly,
the answer?
That's exactly what we're here to discuss, and I have the perfect answer for you. The breach occurred according to, this is on page 65 of the record. There is a provision, subparagraph 4, from the agreement between First Capital and Cabot Lodge. And it says, the director manager, in this case, Cabot Lodge, shall repay any excess O&O collected, any excess of 10% if the offering is abruptly terminated.
And when was that?
The date the offering was abruptly terminated was...
February 12, 2016?
Exactly, yes. I was just about to say that.
Okay, so February 12, 2016. And so what would the statute, or what is the statute of limitations?
The statute of limitations is 6 years, but the breach of this contract was not, in our opinion, when the offering was abruptly terminated. It is when the director manager did not repay the excess O&O money. There is no time specified in subparagraph 4 stating when that money shall be repaid. And that is not an accidental oversight. If you continue on to subparagraph 5, right below it on the same page, it covers a different situation, basically, where a sale is made and then rescinded, and they've collected a commission. and the commission has to be repaid.
So can
And
we-
in subparagraph 5, they get very specific. They say the money shall be repaid within a reasonable time period not to exceed 15 days following receipt of notice by the director or manager from the company for the amount owed.
So counsel, can you compare let's go back to where you started, to 3D4?
Yes,
Okay. So yeah, it does say the dealer manager shall repay to the company any excess amounts received over FINRA's 10% cap. And you're saying it has to be when the dispositive date is when the amount is paid. That's the breach date.
well,
If you go to the first paragraph of 4, it talks about payable as opposed to paid. So what do you say to your adversary's argument that that the accrual date is actually February 12, 2016, because that's when the amount would have been payable?
well, no, but that's not what subparagraph 4 says. It doesn't say it has to be paid on that day. It just says it shall be repaid. And they leave that date
Okay.
ambiguous on purpose.
So let's go a little further, and let's assume that the amount has to be payable within a reasonable amount of time. How is 8 months after the expiration of the statute of limitations, in other words, 6 years plus 8 months, a reasonable amount of time? How do you get beyond the expiration of the statute of limitations?
Well, it's not so much 6 years and 8 months. I guess it's the 8 months is the,
I'm sorry, you're right. Right.
is the real.
I'm sorry, 8 months.
Is the real sticking point on this. Well, the question is, what is reasonable under these circumstances? Now, this was on a motion to dismiss. There was no discovery. The defendants had the burden to show that the statute of limitations had been breached, and that there are no facts in this case right now. I mean, I assume they know the course of dealing between these two companies. I do not, you do not, the public does not. But there may have been a course of dealing between them that would make something reasonable. The dealer manager and the company seem to be extremely close because if you really dig into the facts,
But you're the one who went past the statute of limitations, so how come?
well, yes, but it's their duty. Well, no, it's
So
their
much
duty to show.
confusion
I
so
went
much
past the statute.
confusion today. You're the plaintiff.
Yes,
You brought the suit.
yes.
You brought the suit. The argument is you brought suit past the statute of limitations, past the expiration of the statute of limitations. 6 years, 8 months.
Right.
So again, that 8 months there that you're past the 6 years, is there something in your papers or some argument as to the reason for the 8 months?
Well, Your Honor, we don't know the course of dealing between these companies. It is their burden to show that the statute of limitations has been breached, not us. The question is, what was a reasonable amount of time for them to
their
ask for
burden
the
to
money
show-
to be repaid?
I'm sorry, it's their burden to show that the statute of limitations has been breached?
It's an affirmative defense, and it was their motion below.
Can we
So
can we
it's-
do the math? I mean, seriously, can we just do math that it's February 12th, 2016, and you brought suit in, what is it, October 2023?
22.
Yes.
So,
Well, Your Honor, the question is, was it reasonable in that 8 months for the company to ask for the money to be repaid and for the money to be refused to be repaid? Because when the money was refused to be paid is when the statute of limitations starts running. So the question is, what is a reasonable amount of time
no,
after
it's
February
stated
13th?
that, that's why I asked you when this accrued, right? And it accrued in February 12, 2016. That is when the monies were to be paid, right?
Well, no, and Your Honor, I disagree with that completely. That is not what subparagraph 4 says. It doesn't
February
say.
12, 2016, defendant terminated the offering and the agreement. So under the agreement, that is when the monies were to be turned over.
That's not what the
returned.
agreement says. It just says it shall be repaid. It doesn't say at that exact moment. And they know exactly how to put in language about when it has to be repaid, as you see from the following paragraphs.
Also,
of
so are you
paragraph 5.
arguing that the statute of limitation has not run?
Excuse me, Your Honor?
Are you arguing that the statute of limitation has not run, that you were able to file this case? Is that what you're arguing?
That's what we're arguing, Your Honor. That
Thank you. You have time on rebuttal.
Good afternoon. May it please the court, Nicholas Chrysanthem for the respondent defending Cabot Lodge. Of course, you've all got it exactly right. There are several undisputed facts in this case which are fatal to the plaintiff's claims here. The number one issue that's fatal is that the offering was terminated on February 12, 2016. That's clear, it's undisputed.
But your adversary is arguing, I believe, that although the offering was terminated on that date, there's nothing in the agreement that specifically states when the monies therefore have to be repaid.
Well, there's two issues with respect to that. First, it does actually say that. It says that in 3D4, and it's the last words, it says that it says that, but not limited, I'll read it in the middle, but not limited to selling commissions and the dealer management fee exceed the 10% of gross offering proceeds from the primary offering in the aggregate at the conclusion of the primary offering. The conclusion of the offering here was February, it's undisputed, that the conclusion of the primary offering here was February 12, 2016. In fact, our argument is that the statute of limitations expired even earlier because Cabot Lodge admitted that it was in breach of the agreement far earlier than that. Cabot Lodge took over the offering in this particular matter on September 20th. There's a whole timeline on this whole thing, but that's a particular date because they actually took it over.
September 20th, 2013.
2013.
Right.
In
But then
June-
there was an amended agreement,
Correct.
March 2015.
That's right, and that's the agreement we're working under
Right.
now.
And
But
it's the March 2015 agreement that was terminated in February 2016.
Correct, Your
Okay.
Honor. Correct, Your Honor. And don't forget, in July of 2013, the Cabot Lodge had recognized that it had exceeded the O&O in this particular matter and told the SEC that it had exceeded the offering and offered to do a plan to try and pay back the offering. So that's the first issue. There's no question that on February 12, 2016, the offering terminated. According to that particular clause, which my adversary refers to, it says that it's due on the termination of the primary offering. That's when it was terminated, right there and then. That's number one. Number two, payment is a damages issue here. That's not the breach. That's the effect of a breach, okay? That has really nothing to do with whether or not Cabot Lodge had breached the agreement. Cabot Lodge, at the very latest, had breached this agreement on February 12, 2016, because at that point in time, and my adversary said this let me finish this point, if you may, Your Honor, at oral argument on page 24 of the record there, that not only did Cabot Lodge know how much it had raised, it knew how much it was due. And the complaint states exactly how much it was due. Everybody knew what was due on February 12, 2016. And that's why this case, the order below should be affirmed.
Thank you.
Okay, I'm going to speak very quickly because I have a lot of points to make. One, when he was quoting from the first paragraph of subparagraph 4, when it says at the conclusion of the offering, that is just figuring out how much money is the excess O&O. That is not the provision talking about when it shall be repaid. When he says, when it talks about to be repaid is just a damages provision, that's not true. That clause could have said a lot of things. It could have said, you just keep the excess O&O. It could have said, give the excess O&O to charity. It could have said, keep it in escrow until the next deal and work it off in trade. That is a specific provision of this
But
contract.
the termination occurred in February 2016. Regardless of how you were going to address it, you know, whether the monies were going to go to another offering or what have you. The termination of this agreement took place in February of 2016. So that would be when your rights accrued.
And that is when the calculation is made. We argue the right accrues when the money has to be repaid. The money has to be repaid when they ask for the money and when it's refused. When it's refused, when they refuse to repay the money, is
And
when
what
the
is that-
cause of action on breach of contract accrues in this case.
Okay, so do you have any cases or anything to support your position that that's when it would accrue, is when you ask for it or when it's actually paid?
So, Your Honors, I would direct you to a case we quote in our brief, the Minkskopf case. It looked like it was a real estate contract. There was a 1% success fee to be paid if the deal went through. The deal went through in 2008. I might not have the years right, but over 8 years later, whoever was owed his success fee said, I want my $320,000, which is my 1% success fee. And bear with me 1 second, I wrote down.
So counsel, I'm going to jump in because of the time.
Yeah.
So we're talking about $6.5 million. We're talking about a whole lot of money, at least in my calculation. And I don't understand. There was no effort to recoup that money that was owed. There was no back and forth. Why wait 6 years and 8 months? Only because you thought that the language could be ambiguous?
Well, I think you're conflating two courses of action. Why First Capital never went to Cabot Lodge and said, you know, we're teetering on bankruptcy, we're floundering here, we haven't filed financials since 2015, you owe us millions of dollars. Give us our millions of dollars. We desperately need it. Why they never did that, I have no idea.
But you stepped into their shoes knowing that there was an overage.
But, you know, my clients are shareholders of First Capital, and they would like First Capital to go get that money because that would increase the value of their investment. Now, why did they wait 6 years and 8 months? Well, they're not privy to all the facts, you know, of what's going on between them. They don't know why they didn't ask for the money. They don't know, you know, when exactly they first said, if ever, you know, you owe us $6 million. Let's have it. And then Cabot Lodge said, no, we're not giving it to you.
Thank you. Thank you both. Last case for argument, People v. Jonathan Jolivet.
Good afternoon, Your Honors. May it please the Court. Marika Meese for Appellant Jonathan Jolivet. This Court should dismiss the indictment or remand for further proceedings on Mr. Jolivet's constitutional speedy trial claim because there was an extraordinary delay and the prosecution therefore had the burden to prove that there was good cause for it, and they failed in that burden. It is undisputed that this was a 1993 murder. The DNA testing wasn't done until 20 years later in 2013, and Mr. Jolivet was indicted in 2015. So you have a total period of 22 years.
We have 2 years from the period that the DNA was finally or ultimately analyzed, and the defendant was seen as the individual that matched the DNA.
That's correct, Your Honor, but the crucial period here is the 20 years, and it is uncontested.
Why would the crucial period be the 20 years when the defendant was not a suspect or was not under any type of suspicion at that? Well,
he was a suspect, Your Honor. He was questioned, and he was essentially the only suspect that the police pursued immediately after the incident, based on his having had a child with Miss Page.
so he was questioned, but he wasn't under any type of control by law enforcement, right? He was questioned initially, I believe, and
yes,
then that was it?
He He was questioned and he was under the threat of prosecution throughout. But where there has been a substantial delay, the Court of Appeals has repeatedly said, in Singer and the recent case of Regan and elsewhere, that the other factors don't matter, that the controlling factor is whether there's good cause for that substantial delay.
So would not the fact that the DNA, the abilities in terms of DNA testing were not the same in terms of the scientific breakthroughs during that period of time, that once they were able to match, or once there was a match, we're only really talking about a 2-year delay?
No, because the prosecution never established, in fact, that the DNA technology wasn't available. All they said below, in response to Mr. Jolliver's motion, was the technology wasn't available, summarily and conclusively saying that, without any evidence establishing, in fact, that they couldn't have pursued testing. And in fact, that we know that not to be true, because we know that the testing here was available substantially before that. At a minimum, it was available 10 years before the testing was actually done.
But it was not to the sophistication was not such that they would be able to determine whether or not your client was I don't want to say, a definite match, or at least the percentage was higher based upon the subsequent testing ability.
It was available because this wasn't a case involving low copy number testing. But if you look to low copy number testing by analogy, where they could test even smaller amounts down to just a couple of skin cells, that wasn't the kind of testing done here. It was high copy. But they were able to do that in early 2000s. So there's no reason why this couldn't have been done earlier. And they never offered anything below except for this summary statement that they couldn't do it. And the court below focused on the wrong factors. It anchored it on low copy number testing, but even there it didn't explain why between 2005, when that testing became available and used by the very lab that tested here, why that delay between 2005 and 2013 wasn't addressed at all. And he focused on whether the lab at issue had joined the CODIS, and that was also not a controlling date whatsoever for the determination. On appeal, the people offer some additional responses, but those two fail. They admit in their response that this kind of testing was available in the late 1990s. In 1997, it was available, and that it was readily being done subsequently. None of those other facts were offered below about that there should be some natural delay before they apply it to cold cases, or whether there was any funding problem. None of those issues were raised before the court.
Well, it says that OCME, the criminalist Diana Ho, stated that in 1993, OCME could conduct DNA testing only on bodily fluids such as blood due to their high concentrations of DNA, and did not have enough sensitivity to detect the smaller amounts of DNA in skin cells deposited by touching an object.
Right, but that was in 1993. We're not talking about that. They had 20 years during which they did nothing and made zero effort, and DNA technology rapidly advanced. At a minimum, you have, as I said, a 10-year period that's totally unexplained. And as well, that's trial testimony. We're talking about a speedy trial motion that was filed before trial, and all that the people said in response to that was, well, the technology wasn't available. They didn't offer any support for that. And in fact, if you delve at all into the well-established facts about when DNA testing advanced, there was a substantial period here, and the people failed in their burden. So at a minimum, it has to be remanded. I'll save my additional time for everybody.
Thank you.
May it please the court, Noah Shamler for the people. I'll attempt to be brief, but I'll answer.
So under the relevant case law, Ms. Meeks makes an interesting point. Under the relevant case law, do you have to show, or does there have to be some showing as to why? So 1993, you can't test DNA or whatever. Now 2013, you decide that you're going to review and you're going to test. Do you have to make a showing as to what, if anything, occurred during that 10-year period, what you did, what you didn't do, or why you should have done something?
Well, in this case, fortunately, between the court's opinion and the people's representations below, as well as the testimony of criminalist Ho, those facts were actually established. And because of that, whether the case law says you have to provide specifics in this situation where you do not have a suspect, which I would argue you do not have a suspect, you have no evidence to specifically point to an individual, and you require DNA testing. The fact that it's a cold case homicide, you give more leniency. Absolutely, I don't think any case has said otherwise. I think Regan, because they knew exactly who the suspect was, they could have walked up to him and just taken the DNA and tested it. That is the major distinguishing factor.
Well, to some extent, Ms. Meese is arguing that the defendant was also a known suspect, or was a suspect,
However-
because he was initially interrogated after the murder, and also he was, I guess, the boyfriend or whatever of the complaint.
He provided a weak alibi, but an alibi, and they let him go. He ceased being a suspect. They waited, and they actually did everything correct. I can give you a very quick rundown of the dates that would establish the fact that everything was done reasonably here. 1993, the serology was in fact tested. That's according to Criminalist Ho. 2005, LCN testing was accredited for OCME. Now that's important. The defense says, well, there was no LCN testing in this case. Well, there was. In fact, if I may have a moment.
So was there additional testing done in this case in 2005?
No, but I want to point out the testing was in 2013. But on page 377 to 378 of the record, Criminalist Ho says there was LCN testing. What the state was waiting
Sorry,
for,
Criminalist Ho said what?
that there was low copy number testing, my apologies,
Thank you.
done in this case. And what the state was waiting for was that technological advancement. Now that's 2005, they're accredited to do it. I have supplied the court separately with the case People v. McNath. I'm not supplying it for any law that's in it. It's been abrogated by the Court of Appeals. I'm supplying it for the date of the opinion. In February 2010, the first court in the state of New York said that material is now admissible as evidence in a criminal prosecution. So February 2010 is the first time the state knew that it could present this evidence at a trial and it would survive such a review. That's 3 years before the testing in this case. It should come as no surprise that within those 3 years, funding was for the first time supplied to get testing done on those types of cases, and that immediately upon obtaining those resources, that testing was requested, and within a year, the defendant was picked up upon the match.
So is all your arguments you're now making, is this contained in your brief?
Unfortunately, the McNath material is not within the brief, but it goes to the ultimate outcome of the defense requesting a remand for further fact-finding, and the fact that there's a published opinion with a date showing the first time that any court had accepted this material as evidence in a case would basically be the evidence that a remand would elicit. So there's no real reason for a remand for a speedy trial analysis when 2010 was the first time any court said this evidence, and this is an LCN case. I want to emphasize this. If I may have one more comment. The problem with the defense theory here is that they're basically saying we should have gambled and we should have tested the nails earlier because it actually turns out there was sufficient evidence for the HCN testing. But we couldn't know that ahead of time. This is classic Monday morning quarterbacking. We went on the assumption, because there was no obvious serology, there was no evidence of blood, that some advanced technology here, LCN, would be required for all of it. That is entirely reasonable. And that is the reason we gave below in our papers, which is we waited for the technology to advance, and it's the argument that the court accepted, which is that we were waiting for LCN to be accepted and that we could proceed.
Thank you.
Thank you.
Your Honors, the people had McNath available to them and did not make that argument back when Mr. Jollivert filed his motion or on appeal, or alleging it first time here. But that case doesn't matter because although LCN testing was done on a single nail, that nail was only one of 9, and that nail matched to Page alone and wasn't inculpatory. The rest of the nails were tested with high copy number testing, and they never said that they couldn't do it or that they waited. Even if we take 2005 as the triggering date, that's still 8 years before the testing was done in 2013. And in Megnath, it was the first Fry hearing that was held, but LCN was being used in hundreds of cases. And there's evidence in other cases, including the Morgan case that the lower court cited to, where Dr. Craig O'Connor from OCME testified that OCME had been used in, low copy number testing had been used in hundreds of cases.
So
It's wrong to say that, I'm sorry, Your Honor, that 2010 somehow was the first date that they could use it. It was being used.
So in cold cases, do the people have to show that during that period of time, during the period where there's no arrest and they're awaiting technology, whatever, that they're doing something every 6 months, every 9 months, every year?
Yes, because in Singer, the date that the case from the Court of Appeals that predates Regan, you had a 42-month delay. And in that case, they did, the file sat on a detective's desk, and every so often he would go and look through some papers, but not do anything. It's the same thing here. You have to make some effort, even in a cold case, to show that you're trying to do something to move the case
So
forward.
in Singer, was there a quote-unquote known suspect or a person of interest?
I don't know precisely. There wasn't a known suspect as there was in Regan, where from inception.
Right.
I don't think there was even one like here, where Jolliford was in fact the only suspect that they looked at the time of the actual murder. It was a case that remained essentially cold, and they had to do additional work. And because it sat on a desk and nothing was done, like here, having advances in DNA technology, but the prosecution doing nothing to look into whether the testing could be done, at a minimum, this requires remand for further proceedings.
Thank you both.
Thank you.